Mr. Sibal, some unconnected letter was produced by him, my lord, written by the governor.
That you need not deal with. It's, you want to have to get a letter, just see the letter.
I have seen it, my lord.
It has no
I do
bearing
not-
on the matter. It has no bearing on the matter at all.
My lord, difficulty is, I don't have the advantage of being in dual capacity. I am only a lawyer. So I can't argue political issues, which are totally unconnected.
This letter was only, we had to only smile, that's all. Nothing more than that. I mean, there are so many things which I told you at the end of the argument. You just smile, you take it as
My lord, your lordship should smile twice. A, for such an unconnected thing being presented before your lordship, and second, for the content of. Lord,
I don't think you have to really take it.
I'll leave it at that. My lord, second thing, yesterday I
We're
forgot.
not even going to, I don't think even Mr. Sibal expects us to refer to it in our judgment or anything like that. Not
Even he
at all.
has not
Lord,
read it.
second thing, my lord, I
He didn't
forgot.
even read it as Brother Shah says.
He has not even read it.
He has not read it out.
He said contents I will not read, you read.
Is the possibility of an abuse ever the test of the power or its existence? Because can it be? Otherwise, how will your lordship decide anything? Malas? Yes, that phrase comes from Rajnarayan versus Indira Gandhi. Possibility of abuse is not the test of power. Give that citation.
Hindustan judgment. One
I will-
Hindustan construction, some judgment is there.
Also in the Sun Constitution.
Abuse of power
Power.
cannot be the.
Your lordship should judge everything. Oh, what will happen? What may happen? But that's not the question. Here, and your lordship is talking of lesser cases. Here, the constitution was amended to give this power. And the apprehension is, I will not go on 21st to speaker, to EC. I will go to Guwahati because I'm scared of a disqualification. Now, Malas, let us look at the second. I'm giving your lordship extreme examples against myself. You have a full review possible. My review is much more truncated. It takes 1 year for me to get this hearing before your lordships. Your review is immediate on a wrongful decision against the speaker. And your lordship knows Kyoto says, after final decision of the speaker, you can get a stay of that. You can't get a stay while he's deciding. You can get it afterwards. Of the disqualification also. Only a quia timid is stopped.
You're comparing that with what?
With the fact that if you don't do this and stay and make the 10th schedule a dead letter and install a new government on the basis of ignoring the 10th schedule, that is much less reversible by sheer passage of a few days than your right to challenge. Today, minus what is the whole argument? It's a scrambled dead, it's a fake accompli. Your lordships can't reverse it. It's 1 year down the line. That's the real argument today. That's the argument we are facing. Now let me give your lordship another bizarre example against myself. These are not normal examples. Whereas I don't know of except a very few number of cases where you have the courage of conviction to resign and recontest. That resignation is impeded. It happens. There are 2 or 3 judgments we have. But normally, let me assume against myself that I resign because of my high standards and my resignation is not accepted by the speaker. That's the worst I can assume against myself,
Right.
I can't assume something more than that, Again, the speaker can only reject my resignation and disqualify me. He cannot do anything more. The speaker cannot say that you shall do this or that. He'll at the most say, I reject your resignation and I disqualify you. Same remedy. That remedy, your lordship will stay in 2 seconds. Suppose your lordship had an MLA who resigned to fight a new election and the speaker, there may be bizarre cases, I don't know. Speaker said, no, I disqualify you. How long will it take a court to give a stay of that order, I mean, your lordship is dealing with these cases on and off every day, in some form or the other. But here, none of these 4 or 5 possibilities is allowed to be tried. Because you adopt a 3-step procedure to annihilate the 10th schedule. Which brings us to the harmonization principle. I'm not going to cite law about harmonization. From ordinary petty contracts to constitutional law. Your lordship's first principle is harmonization. From statutory, delegated legislation up to the constitution. Whereas I want to make the different point here that why did the 10th schedule come? We'll read Mr. Ashok Sen's speech in when he piloted this 85 thing. The whole purpose is that you have come through a party seat, you go and face the electorate again, whether with that party, independent or a third party. That's the whole long and short of this, Malus. Malus, have your lordship ever heard this happening except in some very rare cases in England or other democracies? There's no concept, I've come on a party, I'll either resign or I'll Malus, just leave that and fight again from another party. That was the whole purpose of this. But what you are telling the court is that no, I will affirmatively not resign. I will not go to the EC. Why? Because I am scared that somebody will disqualify me. But then what was Mr. Ashok Sen enacting in 1985, Malus? He's enacting a power of disqualification for changing your party. You don't have to, Malus, voluntarily give up your party. You say, I'm on principle, please decide this.
So in other words, you are saying other than those 5 instances,
Four now.
Everything else falls within the net of 10 schedule.
And one more thing I am saying. That 10 schedule, absolutely correct. And the 10 schedule has both parts. It has those 4, it has a negative. It Malus creates a whole code by itself. Harmonization means that your lordship will adopt my submission and interpretation because it harmonizes the negative and the positive. Now for 30 seconds, see if your lordship does not adopt the harmonization principle. The only thing a lordship will have to validate is a 3-step procedure. There's nothing else, Malus. It's staring a lordship in the face. The 3-step procedure, I want to ask myself, Malus, in which case will the 10th schedule bite? Let's, Malus, be very blunt. What your lordship will do is your lordship's domain. But today, your lordship's other option, other than my option, which I am submitting most humbly and respectfully, is adopt the 3-step procedure or validate it or recognize it. Malus, then how will 10th schedule apply? It cannot. And then, Malus, your lordships would be actually adopting an interpretation which reduces the 10th schedule to vanishing point. Actually vanishes, that vanishing point, it vanishes. Every case of defection, I will say, I will not resign. I won't go to the EC. I won't merge. Merger is given to you by the para 4 of the 10th schedule. I will not do it. But, as your lordships was told, I am the party, I am the overwhelming majority, I am the main person, I am it. I am it. Therefore, to hell with the 10th schedule. So, Malus, on principles of interpretation and much more so of constitutional interpretation than even statutory, this is a much better way to look at it than, Malus, the contrary view. Because your lordship, Malus, gives meaning to both sides and your lordship does not adopt something. What is this other adoption which is propounded to your lordships? On the high moral principle of democracy, dissent, free speech. Each of my 4 options gives you that option. So what the 10th schedule does is, it says, I am giving you a free speech option. I am giving you a democracy option, but within my own terms. I am not giving you a jungle raj free speech and democracy option. Otherwise, why would I enact a 10th schedule?
See, but merger, Dr. Singhvi, was not an option open to them because they were not claiming to merge their party with either the BJP or any other party.
With respect, I'm sorry to interrupt, Malus. Why not?
So, merger was not an option.
No, it was an option. Malus. They did not choose to exercise it.
You're right, you're right.
That's correct.
It's an option.
They chose not to exercise an option.
In the abstract, but they were not following the merger route at all because it's not their case that, look, this part of the Sena
That's exactly
has
my point.
merged with another party. That is not
That's
clear.
exactly my point with greatest
Then
humility.
the only point is that in a situation like this, where they say that we have lost faith with the leader of the party,
Yes.
then the only option according to them, according to you, is that you resign and recontest.
No, Malus. No. I will stick to my 4 options.
That's
I'll say all the 4 options are available.
No.
No.
What do they do then?
No. Whereas resign is one.
Right.
These 9 people will merge with another political party. Why not? But the fact that I don't exercise an option
That is not an option because merger means that their political identity as the Shiv Sena is lost then.
Well, then in that case, if the 10th schedule says that I recognize only this path of exit from this room, you can't say I'll make a new tunnel to get out.
But Dr. Singh,
He can't make a
part
new-
of your argument is a problematic argument.
It's a
That look,
problematic.
I'll tell you why. Because your argument postulates that if you have a dissension, then the only way you can express the dissension is to leave the party and merge somewhere else.
One.
They say, sorry, we don't want to leave. I mean,
Right.
ideologically, I am a Shiv Sena man. I don't want to leave, he says. He says, I don't want to leave the party.
So as per your
Kindly see, Malus,
argument,
now kindly see the
even
consequences of it.
if somebody applies to the election commission at the
Yes.
initial stage instead of in the legislative assembly.
Correct.
And says that we now want the political party to.
That we are the
accept us
political party,
as-
recognize us.
So even that, according to your argument, is impermissible then.
No, because
So because that's outside the
so long as,
5 instances that you have given,
no. One of my 5 is EC.
he's not resigned.
I beg your pardon. No. One is resignation, one is split, which is gone now, one is merger. The fourth is EC.
He's saying that.
Fourth is EC.
Okay, the-
Now, whereas if I apply to EC without violating a whip and get a decision, if I apply to EC without voluntarily resigning, it's perfectly permissible. I can't be saying I'll topple first and then I'll apply to EC.
So remain a member, be a part of it and
And
contemporaneously.
vindicate your principle. Absolutely. But I just see the reverse of it. But just consider how it will apply. You first topple the government, then you go to the EC. And why did you like the 10th schedule?
That we understand.
No, and Malas, also, apropos my Lord Chief Justice query, Malas, are you harmonizing or not? Malas, one more thing. The fact that you don't choose consciously not to excise an option does not mean you can wish away the option. The option is a constitutional option. It's a constitutional option. It's as equal to split as it was earlier. You don't exercise it, it really amounts to saying this, I want to avoid the 10th schedule. So I will put blinkers and close my eyes to 4 options available. 4 constitutional options, the 5th one is deleted. And I will choose a new option, which is only the 3-step procedure. First, disable the speaker. Second, approach the governor. Third, be sworn in.
See, the negative prohibition in the 10th schedule is twofold. One, voluntarily giving up a membership, and 2, defying a whip, 21A, 21B. The 10th schedule certainly does not have any provision by virtue of which there is a prescription if you do not give voluntarily, if you do not give up the membership of the party, and yet exercise the right of working your remedies within the party.
Then you cannot be held to be a defector.
Right.
And that is the whole purpose. You were elected.
That's exactly the case, no?
No, but Balas, then in that case, why did you enact the 10th schedule? Balas, 10th schedule is not Balas saying that Balas, Article 19(1)A, just see 194, Balas, very interesting article.
That is the.
It is not saying